Mr. Hanson, now if it helps, in relation to the cessation issue, the aspect that we invite you to focus on is really the first of the 6 points.
No baseline consideration is my note.
Sorry?
No baseline consideration, I think, were your
Yes, exactly.
words.
Did the whatever else may have happened? Did the tribunal
start in the right place?
Yes.
Just before you get to that, you were dealing before lunch with the Article 3 point.
Yes.
We have your replacement skeleton, which you say effectively encapsulates all the various matters you raised with us this morning. Your skeleton provided about a month before, on the face of it, says precisely the opposite. And it says, the Secretary of State has accepted that it was wrong to cast a burden on the applicant to adduce evidence about the availability of suitable medical treatment in the receiving state.
Yes. Well, as I think we endeavoured to explain, the Secretary of State reconsidered her position and considered that concession was wrong. And in the light of the fact that the case hadn't settled anyway, we put in a fresh skeleton, making the submissions that we have.
So you just decided what you'd originally thought was wrong?
Well, I can't say much more than that without trespassing on issues of legal professional privilege.
You follow that, yeah. All right.
I mean, there's more to it than that, but I can't say any more than that. Just before I leave Article 3, I'm not going to ask you to turn up another case, but I would ask you to note TC. It's in the authorities bundle, it's hard copy, page 777. For this reason, it's the most recent decision of a presidential panel in the Upper Tribunal, June 2023, on Article 3 medical issues. And paragraphs 41 to 53 in my submission support the overarching submission that I made earlier, which was that the settled position at the moment, rightly or wrongly, subject to this court's rulings, is that it is for an applicant to lead evidence on the availability / accessibility of appropriate treatment in the receiving state. That is the settled position in the Upper Tribunal at the moment. And TC shows that in graphic terms because the issue joined was precisely as to whether the tribunal had wrongly reversed the burden of proof and put it on the Secretary of State.
Now, where in this very long sidebar do you want us to alight?
It's really paragraphs 52. The context is set out at 47 and 48, but the real meat of it is 52 and 53. In particular, the last sentence of 53.
So this was a this was an appeal from a successful appeal against the decision.
Correct. The appellant succeeded before the FTT, and the Secretary of State appealed.
So I mean, it's interesting to see what happened in this case, but what does it add to our store of knowledge about the principle or practice?
Sorry?
What does it add to our store of knowledge about the principles or practice
Well,
that ought to
it,
apply?
in my submission, it demonstrates the submission I've just made that the settled practice in the upper tribunal, as a matter of principle, is to require an appellant to adduce evidence at stage 1 dealing with availability / accessibility of medical treatment in the
Right, and
receiving state.
just because we've been reading a page or two at speed, where is that particular point best made?
The last sentence of paragraph 53.
And how does that distinguish this case? There's a different question, but how does that distinguish this case from that one?
Well, it simply lends support in my submission to my overarching submission that the way to approach these cases in principle is as I have submitted.
All right, paragraph 53.
To require the appellant to adduce evidence directed to this issue at stage 1, and if they don't, they fail in limine.
Yes, right. So is that it on Article 3?
That's it on Article 3.
Thank you. Now, we're back to the indication I gave you a moment ago.
I'm great.
Yes.
Can I invite you to go back to MA Somalia, which is in the authorities bundle at page hard copy 416. And I think it's sufficient for my purposes just to take you back to paragraph 2 in the judgment of Lady Justice Arden, as she then was, where she effectively gives her conclusions at the beginning. And the important point for my purposes is her sub 1. I've concluded that a cessation decision is the mirror image of a decision determining refugee status. By that I mean the grounds for cessation do not go beyond verifying whether the grounds for recognition continue to exist. And then she goes on about significant non-temporary. And just to, I'm not sure I understood my learned friend correctly. I apologise if I didn't, but the next sentence beginning the recognising state, I think runs counter to one submission he made. Lady Justice Arden there says recognises it does not in addition have to be satisfied that the country of origin has a system of governance or an effective legal system, etc. I may have misunderstood his submission. I thought he said that was part of the inquiry. And I say it's a pure mirror image approach. That's what the case law...
That was obviously, you'd appreciate a case which concerned whether there was a functioning state at all.
Yes.
And so I think the point that was being made there was that it wasn't that one had to establish all of that.
No.
It was you had to focus in on what was really at play in the
Yes.
individual case.
But applying the mirror image approach and going back to the 2010 minute of decision, the grant of asylum, I'll take you back to it if necessary. You'll have it very fresh in your mind. Asylum was granted because there was a conclusive grounds decision that the applicant had been trafficked. And as at that date, 2010, there was a risk of her being re-trafficked. That was the basis of the grant of asylum. And so our submission, applying the mirror image approach, is a very simple one. As at 2021, those risk factors cease to exist. She wasn't at risk of re-trafficking. And insofar as the original risk had been based on a debt, I adopt your lordship's point, the clear finding of the first tier tribunal was to the effect that there was no live debt, to use your lordship's words, due to the passage of time, such as to put her in peril. And so I say there is no merit in this point. The judge correctly directed himself in law. He reached permissible conclusions in relation to the risk of re-trafficking, closely reasoned in my submission by reference to, in particular, the recent fact-finding mission. It's not unusual, in my respectful submission, for a first-tier tribunal to place preeminent weight on that type of evidence. It's very persuasive. And the relevant non-governmental organisation, Hagar, said there was no risk of re-trafficking, and we're not aware of any case where a victim had been re-trafficked. So we have, in my submission, applying the mirror image approach, solid grounds for revoking her refugee status.
I don't want to attempt to do it myself, but my recollection and understanding of Mr. Jafferty's submissions to us earlier was that it was a little bit more complicated than a mirror image approach, and that, and as it were, the way out of refugee status may not be exactly the same way as the way into it in the first place. Do you sense a difference in your submissions? And if so, what would that be?
I mean, I don't sense a difference of principles. I mean, I agree with him, and one can perhaps see this in MA Somalia. If we just go back to that for a moment, if one looks at the top of bottom of 418, top of 419, Lady Justice Arden says, thus the relevant question is whether there's been a significant non-temporary change in circumstances, such that the circumstances which cause the person to be a refugee have ceased to apply, and there is no other basis on which he would be held to be a refugee. So that admits of the possibility that the circumstances of recognition have ceased to exist, but there are other circumstances that militate in favour of retaining status. So I accept that much, but I say, in considering revocation, it is a pure mirror image approach, and there's nothing in the other circumstances, and it's not part of this appellant's case, certainly as pleaded, that there were other solid grounds for not revoking status. That's all I propose to say on that point. Unless I can assist further, those are my submissions.
No, thank you very much indeed, Mr. Hanson. Mr. Jafferty, I think we're likely to take the view that anything that appeared on the face of the respondent's notice has, as it were, been caught up in general submissions in response to your appeal. So we don't require a formal response to a respondent's notice from you. What we would like in regard to the Article 3 issue to have your help with is the submission that Mr. Hanson has made about the circumstances that have to be, the evidence that has to be led in order to shift the burden.
The test, my lord, yeah.
The test at stage 1.
Yeah.
That's where the line is to be drawn between stage 1 and stage 2. Is it precisely as Lord Wilson put it, or following his examples of cases where, as it were, a feeble Article 3 case has been
Yes.
presented, would that in itself cause a shift in the burden, or can the tribunal, in a sense, be trusted to identify for itself cases where the burden has or has not shifted based upon its knowledge of the case as a whole? We'd really like your help about that, because
Yes.
whatever happens to the appeal, that's clearly a matter which has been raised in the grant of the grounds of appeal. It's been argued by the Secretary of State, and you yourself have helped us on matters of that sort. So the Popashvili and AM argument, we'd like to hear from you on that, together with any other matters that that you feel
Certainly.
deserve a response.
My Lord, in relation to that test, if I could just start by making the observation that I think my learned friend made, and I think might have been made from the bench as well, that by the time these cases get to the Court of Appeal or the Upper Tribunal or the European Court of Human Rights or even the FTT, there is inevitably going to be evidence from both sides, because the consideration process has already started with an initial decision by the Secretary of State. So it's a rare case where you have no evidence from the appellant and no evidence from the respondent. In one sense, this is one of those rare cases because there was no evidence from the respondent before the FTT or the Upper Tribunal, and there remains no evidence. And there isn't a CPIN or any country information with respect to medical treatment available in Vietnam. So there is a complete absence of evidence from the Secretary of State, but there is some evidence from the appellant. That's the practical way in which these cases inevitably unfold. Appellants rarely take the position that we simply won't produce any evidence because we're not required to. There's a belts and braces approach. They want to make their case and make it as best they can. But as my learned friend rightly said, it is important for the court to give guidance as to what the correct approach is, because that will make a difference, and that difference is clear from the outcome in this appeal, where the FTT had evidence from the appellant, placed the burden on the appellant, and therefore found against the appellant because it found that evidence wanting. Had it placed the burden on the Secretary of State and found the evidence wanting, the appeal would have been allowed because of the threshold issue. So that's the general sort of background and context to this, and it's important because when one looks at the cases, there is always evidence from the appellant. And because there is always evidence from the appellant, in pronouncing its judgment and in giving its reasons, the court always refers to that evidence. And therefore, the Secretary of State points out that, look, in its conclusion, it says the threshold was met because of X, Y, and Z evidence. Now, that is the case on the facts in each of these cases, but it doesn't mean that the principle established in Papashvili and explained in AM Zimbabwe, that there is a shifting burden, doesn't apply and shouldn't apply. That is important because in cases like these and other cases where the evidence is contested, where the burden lies will often decide how the appeal is decided, especially when you have contested evidence. And you could have eminent experts. You have an expert here whose expertise has not been doubted, but the first-tier tribunal found difficulty with his report for the reasons it has given. We say that there hasn't been full consideration of the report, and we'll take you through it. My lords and my lady have already looked at the report and are clearly familiar with it. But in determining that sort of case, it is important to know where the burden lies, because that will determine the outcome.
Well, in this particular case, there was certainly a submission, see paragraph 79, on your client's behalf that she would not be able to access medical care in Vietnam due to registration issues. I presume there was a statement somewhere, although we haven't, I think.
From the appellant?
The appellant.
I don't think there was, because I've seen the appellant's bundle that was before the tribunal, and there wasn't a statement from the appellant, and I think that might be because taking that statement was difficult due to the trauma.
But I mean, in the normal case, you might expect statements, but you would say that in cases where there was, for example, a serious psychological condition, that might not be necessary or appropriate.
Yes,
it might be, in other words, the evidence might be given by somebody else.
That's right. I think ordinarily the evidence would come from a medical expert and a treating doctor or medical records, because the issue, as my learned friend has set out and is not in dispute between the parties, is there a serious illness, and what will be the consequences to the applicant's health if that illness is not treated on return. And if I could take my lords and my lady to the authorities, and start with.
Sorry, just before you do
Yes.
that, so I've got to clear in my own mind. In this case, Home Office produced no evidence at all about
That's right.
medical
No evidence at all.
facilities in Vietnam. So all the judge had was, and your case is, well, that raised at least a prima facie case, which unmet was
Should have led to the appeal being allowed.
should have led to the appeal being allowed. Suppose that in fact the Home Office had adduced evidence, whatever form, tending to undermine Dr. Tran's evidence or explain it or put it in a different light, that would allow at least a conclusion that there was no serious risk of a violation of Article 3. Do you accept that, assuming the evidence is all there, the burden is on the appellant to demonstrate the risk of Article 3 violation?
The overall burden is, but you will see from AM Zimbabwe, and I'll take you to the relevant paragraph, that what the European Court of Human Rights did in Papashvili is changed the usual approach to burden in an Article 3 case. And one of the submissions that we would make is that if the Secretary of State's position is right, it really doesn't take us anywhere other than the usual situation where you have an Article 3 claim. It's for the appellant to make it out.
Yeah.
And if the appellant advances evidence that shows that it could be made out, the Secretary of State will respond. That's the usual way
Yes.
an Article 3 claim would be dealt with at the tribunal. So if we're going to depart from that, there has to be something different.
No, what I'm just trying to establish
Yes.
is, if all of that happens,
Yes.
then it is for, in this case, the appellant to establish the Article 3 violation. It's not for the Secretary of State to demonstrate it wouldn't be violated.
I think the way I would put it, my lord, is that overall it is the appellant that bears the Article 3 burden, but
Yeah.
that is adjusted in medical cases per the judgment in Papashvili, so that if the initial threshold is met, there is then a burden on the Secretary of State to show that there would be accessible and available treatment.
Yeah, I follow
If the
that.
Secretary of State cannot discharge that evidential burden, then the appellant's burden is met.
Yeah. The
If
legal
if there is evidence produced, I suppose it is for the tribunal to then adjudicate upon that evidence. I would submit that per the test, that stage is firmly in the Secretary of State's court, because the burden is on her to produce the evidence.
Yes, but having produced it,
Yes,
the tribunal then has to make a decision,
yes.
and the burden is on the appellant to demonstrate the violation of Article 3 on the whole of the evidence.
I suppose what my lord is asking, is it simply a procedural burden, or is it a burden of substance? And we would say it's not just a procedure that you produce evidence and show that here's why it would be safe. That evidence has to be assessed and be found to be credible. And if the evidence overall is wanting in any way, it is the appellant that prevails, not the Secretary of State.
That's a judgment that the tribunal will reach.
Yes.
But that will be because the appellant has satisfied the burden that lies on him or her to demonstrate a violation of Article 3.
Yes.
Yeah.
But I guess the route to that is that the Secretary of State did not discharge the burden upon her within that exercise. And perhaps if I could take my lord...
I'm terribly sorry. I
Yes.
fully understand.
Yes.
In this case, that's not what we're talking about.
Yes.
I'm just trying to understand.
No, I appreciate that, and it's not a straightforward point that my lord has identified. I don't think it has been dealt with in that way in any of the cases, as far as I'm aware. It's
Could
almost dealt.
could we take this example? And
Yeah.
I may or may not be addressing exactly the same point as my lord has, but I don't think that we would wish to be in a position of saying that the evidential burden was like a sort of tennis game in which simply because the Secretary of State had not put in a document filed by the Secretary of State, that was an end of the matter with regard to the evidential burden. It's possible to imagine a situation where the Secretary of State says, fine, well, we're prepared to accept everything that is in Dr. Tran's report, except for these points, which don't arise from the material which he has referred to. We're happy that the evidence should stay as it was, and we're going to make submissions to you about it. Now, the evidential burden, as it seems to me, doesn't involve an obligation to produce paper, but it does mean that on that particular finding of fact, it's up to the Secretary of State to prevail if they want a different conclusion in relation to availability and accessibility of treatment. I mean, isn't that how it works? That the evidential burden, which is spoken of in AM, comes into effect with regard to a finding of fact in the context of an overall assessment of Article 3, which remains with you throughout.
My lord, I would submit that the evidential burden does require the production of evidence, and it cannot simply be that the Secretary of State challenges evidence produced by the appellant and says we accept this, we don't accept this, and then the tribunal adjudicates upon it. And I say that based on what is said in the cases. Perhaps if I could take, with a focus on this point, take my lords and my lady to the cases, and perhaps starting at the bottom, without meaning any disrespect, in terms of the upper tribunal, because there is a very straightforward paragraph in the head note of AXB, which can be found at page 595 of the authorities bundle. It might be 596 of your version. And if I could ask my lords and my lady to read head note 3.
Yes.
And the appellant's position is that that is the way in which the test unfolds. And if it needs clarification, the first sentence in terms of the burden being on the appellant relates to a burden to establish the serious illness and the consequences of removal with lack of treatment and access to treatment being sufficient, arguably, to pass the Article 3 threshold. It's a threshold test, which is not the same, we submit, as a test that requires you to make out the full case at that stage. If I could take my lords and my lady then to AM Zimbabwe at the Supreme Court. That's at 318, be 319 of your bundles, and the operative paragraphs 32 and 33. And my lords and my lady will see that just above F on the side of the report, the sentence beginning the basic principle is that the passage there to just above G shows that the usual burden of proof is adjusted in Article 3 claims relating to ill health. So there has to be some adjustment. We cannot have a situation whereby it's the same as the usual Article 3 case, which in my submission, the Secretary of State's submission is essentially advocating. There is no difference in approach to the usual Article 3 claim if one accepts the position advanced by the Secretary of State that it is for the appellant to advance all of the evidence, and it is only if that evidence is capable of showing a breach of Article 3 that you get onto a shifting burden to the Secretary of State.
When Lord Wilson said that H, and referring here to what Lord Justice Sales, as he then was said, all three parties accept that Lord Justice Sales was correct to describe the threshold as an obligation on an applicant to raise a prima facie case of potential infringement of Article 3. This means a case which, if not challenged or countered, would establish the infringement.
That's right, my lord. So we read that, and I'll take my lord to Savran as well and what is said there. Savran essentially endorses Papashvili, but it says in applying the Papashvili test, it makes important remarks that, in my submission, clarify the position in terms of burden of proof and support what is said at paragraph 33 and the appellant's position. So what we say is that because of the test being modified in an Article 3 ill health case, what the applicant has to show, and it's not an easy burden to discharge, as all of the cases say, it's a high burden, serious ill health, and evidence that shows that if the treatment and care that is being received is withdrawn, there will be a rapid deterioration or a substantial reduction in life expectancy. That is a burden that the appellant must discharge. If that burden is discharged, it is then for the Secretary of State to say that you won't suffer those consequences because the requisite health and care, the medication, health care and support is available and accessible. And so when one talks about a prima facie case in the context of the shifting burdens, that is right, that you show that your ill health is such that withdrawal of the treatment and care would result in the requisite suffering. If that is not counted, your case succeeds, and that is the third head note from AXB. Of course, in the examples given by my learned friend, that wouldn't be a heavy burden on the Secretary of State at all. She's able to produce and access general evidence about healthcare provision in the European Union, in the USA and other states, where there would very readily be an answer to a case that there would be a breach of Article 3 if I were to be removed to the USA, to France, to Germany, because there would be material in the public domain that would show that the healthcare is clearly available. And the Supreme Court also qualifies the doubts that need to be dispelled to serious doubts. So it might well be that one doesn't get to that stage because clearly the healthcare is available, and there wouldn't be a difficulty in showing that. So this isn't this test and the way that it unfolds in the appellant submission isn't something that will cause undue difficulty to the Secretary of State. On the contrary, it simplifies the position so that all parties are clear as to what needs to happen, who needs to do what. If one adopts the Secretary of State's position, we have a lack of clarity, because on the one hand, the appellant has to adduce evidence about the country conditions. On the other hand, so does the Secretary of State. And it will be difficult for tribunal judges to differentiate and ascertain where to draw the line. When does the appellant's burden stop and when does the respondent's burden start? And you'll have the sort of difficulty that potentially arises in this appeal if one accepts the Secretary of State's reading of the FTT determination. And the reasoning for all of this is set out very clearly at paragraph 33 by the Supreme Court. The premise behind the guidance, which is surely reasonable, is that the applicant adduces evidence about his or her health conditions and the consequences if treatment is withdrawn or care is withdrawn, but the returning state is better able to collect information about the availability and accessibility of care in the receiving state. And that, although my learned friend seeks to place weight on the first sentence, in the event that the applicant presents that evidence, what that passage from the judgment is doing is providing the reasoning underpinning the stages of the test. And that reasoning is very clear. And in my submission, it's consistent with Papashvili. It's consistent with the AXB and the way the upper tribunal has dealt with the burdens there. It is also consistent with Savran. And if I could take my lords and my lady to Savran now, I hope that you will see the way in which the appellant says the test clearly needs to be applied. The relevant page, my lords and my lady, will just give me a moment. It's paragraph 133, which is at page 226 of the authorities bundle. At that paragraph, there is clear affirmation in the last sentence of the standards and principles established in Papashvili. At paragraph 135, the test is described as a threshold test. And typically a threshold test means getting into the ballpark of Article 3, not an unfounded claim. If one then goes to paragraph 140, the application of the relevant principles in the present case, you can see clearly reference to the threshold test, and only after that test being met, any other questions such as the availability and accessibility of appropriate treatment becoming of relevance, which means that they're of no relevance prior to the threshold being established, which means they don't form part of the threshold test. And that is consistent with paragraph 33 of AM Zimbabwe.
And the assessment of whether the threshold test is met is a matter for the tribunal.
That's right.
Yeah.
That's right. But it is based, we say that it is based on medical evidence,
Yes.
but it's a matter for the tribunal.
Well, it's based on medical evidence which can be given from different sources.
My lady, yes. One would typically expect it to be from a treating doctor, an independent expert that has assessed the medical records, but it's going to be from somebody that can give evidence about the health of the applicant and the consequences to the applicant if the current treatment and care is withdrawn.
Which is what the psychiatrist did, my apologies for interrupting, it's what the psychiatrist did in this case, because a specific question was addressed to the psychiatrist, which then was answered in his report.
My lady, yes, and I will, if time permits, take my lady and my lords to the psychiatrist's report and just refer to paragraphs, because the parts that are quoted in the first tier tribunal's determination don't fully reflect what the report says. The medical condition is severe, the current presentation in terms of symptoms are severe, and the consequences are clearly going to be severe. And it isn't for the medical expert to step into the shoes of the tribunal judge and give an assessment of the Papashvili test. The role of the expert is to give evidence about the symptoms and the consequences. Whether that meets the test is something that the judge is to do. And typically, if an expert strayed into that arena, the judge would criticize rightly the expert, because that is not the expert's job. The expert's job is to give the evidence. The judge then decides whether the threshold is met or not. And we say that clearly in this case, the judge accepted the evidence and rightly found that the threshold was passed, because the report shows very intense current suffering, consequences being severe, in addition to the suffering, a clear risk of suicide, a heightened risk of suicide. So at 140, we have that clear statement. And then if I could take my lords and my lady to 147. Again, the reference is that the foregoing considerations enable the court to conclude that the threshold has not been met. Against this background, there is no call to address the question of the returning state's obligations. And if one looks at the considerations, they all relate to the medical circumstances. And although on the face of it, when one reads the sort of headline diagnosis for this appellant, Savran, psychotic and schizophrenic, it seems very severe, and no doubt it is a severe condition. But when one is looking at that in the context of the severity required for Article 3, one can see from the background that is set out in the judgment that the evidence of the medical condition was evolving over time. And at 140 onwards, where the court reaches its conclusion on the medical evidence, it's clear that the court wasn't convinced that the conditions were so severe that they would cause intense suffering. There was a risk of offending, aggression, but that was not intense suffering that the applicant would suffer from. So the evidence there was very different to the evidence in this case. Each case, of course, turns on its own facts. But what is clear in my submission in Savran is that it is adopting the approach that the Supreme Court in AM Zimbabwe discerned from Papashvili, which is that the appellant's burden is to produce medical evidence of the conditions that he or she is suffering from and the consequences for him or her if the current treatment, medication and care is withdrawn. Once that is done and it reaches the threshold, it is then for the Secretary of State to show that there would be treatment available and accessible. And the appellant would say that paragraph 140 of Savran makes this very clear. If one reads 33 of AM Zimbabwe, 140 of Savran, and then AXB, those are three cases that clearly support the appellant's construction. We say that that is a sensible construction because otherwise, not only is there confusion in terms of who needs to produce the evidence and who bears the burden, but also it is contrary to the reasoning in AM Zimbabwe at 33, whereby the appellant is not going to be in a position to provide that evidence.
All right, well, can you then deal with the thought experiment that Mr. Hansen gave us, which is deportation to France?
Yes.
Are you saying that in a case where somebody just happens to be ill and is the subject of an attempt to deport, that it has to be part of the Secretary of State's evidential task to produce evidence about the general availability of healthcare in France?
If we take these facts, and this appellant said that there would be a risk to her of Article 3, non-compliant Article 3 treatment on return to France, then yes, there would be a burden, but that burden would not be so difficult to discharge because of the publicly available evidence. The I think Supreme Court and the European Court of Human Rights refers to reports from WHO, publicly available information. I would have thought that that information itself would be sufficient. There would be no reason to go on to the third stage,
Yes,
which is making...
One might have thought that the fact that you happen to be very ill and you're being deported to France doesn't put people thinking in terms of Article 3 at all. So, I mean, is it your suggestion that simply because a person happens to be ill and is being deported, that they simply have to mention Article 3 and a burden passes?
My lord, no, not at all. There is as I said, there is a high burden on an appellant to show that the illness is of sufficient severity and that the consequences of withdrawal of treatment would be sufficiently severe. Those tests need to be satisfied by the appellant.
Yes, but that's not saying much more than I've just said, which is that you're extremely ill and ... dependent upon treatment.
It would need extreme illness, though. So it
Yes,
wouldn't
I
be the
understand
normal...
that, but what you seem to be suggesting
Yes.
is that everybody who's extremely ill and getting deported will have an Article 3 case unless and until a successful Article 3 case, unless and until the Secretary of State shows they're going to get treatment. I mean, the answer to this, I feel that we're coming to the point where we're dancing on the head of a pin, and I know
Yes.
that's the last thing that you want to do. But from AM, it seemed to me that what the appellant would need to establish, I don't mean your appellant, but an appellant would need to establish, was that there are serious doubts about the availability of treatment. And once they have put up a credible case of serious doubt, at that point, the Secretary of State has got to show that the doubt need not trouble the decision maker. And I don't see really, in a sense, that there's very much.
I suppose, my lord, the way to
Difficulty with
test
that.
it would be that if this appellant had simply produced the medical evidence and not produced the report from Dr.
Tan, yeah.
Tan, would she have surpassed the first stage? And the appellant would say that yes, although on the facts of this case she did produce evidence with respect to availability and accessibility, and that was an expert's report. I think there were 3 versions of it, 2 updates. If she hadn't have produced that, we say that the fact that the withdrawal of treatment would result in serious consequences sufficient to meet the Papashvili threshold
Right,
would
so-
shift the burden. But that is an exacting test. It's not an easy test. It's not that every seriously ill appellant would meet that test. And I would expect that the Secretary of State's first line of defence would be the illness is not severe enough, the consequences are not severe enough, your medical evidence doesn't meet that initial burden. So that isn't a light burden that each applicant bears. But once that burden has been discharged, then it is for the Secretary of State to produce evidence about the availability and accessibility of treatment. That doesn't mean that the appellant doesn't need to do anything in response. If the appellant provides no evidence and the Secretary of State provides evidence that it is available and accessible, the tribunal is likely to find that it's available and accessible. So that evidential picture will be evolving in front of the first tier tribunal. But the stages in my submission are clear. The appellant must show the consequences for his or her seriously ill health are going to be intense suffering that's irreversible or near death. Once that heavy burden has been discharged, the Secretary of State must respond. And in many cases, that response will be fairly straightforward, because in many cases, the Secretary of State will have a CPIN on medical conditions in the relevant country. In many cases, that evidence will be available online from the WHO or any other international organization. That is what is envisaged in AM Zimbabwe and in Papashvili. Those are the primary sources that one would go to. And one would expect that most cases would be resolved at that stage. It's only the very serious ones where doubts still remain that you get onto the third stage where the Secretary of State has to make specific inquiries. And that is a clear-cut way to approach this. Otherwise, we get mired into uncertainty, because at the very first stage, you're overlapping into the second stage, and one really doesn't know where the appellant's burden ends and where the respondent's burden begins. So this solution has the benefit of clarity. It doesn't place an undue burden on the Secretary of State. It's consistent with the reasoning in AM Zimbabwe. It's consistent with the way that Savran has dealt with the test on the facts of the case before it. And in my submission, it also ensures that what the Supreme Court said in AM Zimbabwe at paragraph 32, that there is an adjustment to the Article 3 burden, is actually, the burden is actually adjusted. Otherwise, you're in the same position as you would be if you're alleging a breach of Article 3 because of torture. You have to prove it. You have to provide the country evidence. And the Secretary of State only responds if you've done that. What is the difference between the approach advocated by the Secretary of State and the usual approach? In my submission, there is no difference.
Can you help me, going back to Savran,
Yes.
paragraphs 134 and 135. This is simply Savran saying these are the principles established in Papashvili. First, the evidence adduced must be capable of demonstrating that there are substantial grounds for believing that as a seriously ill person, the applicant would face a real risk on account of the absence of appropriate treatment in the receiving country or the lack of access to such treatment of being exposed to a serious, rapid and irreversible decline in his health, such as to lead to a violation of Article 3. Second, it's only after this threshold test has been met, and thus Article 3 is applicable, that the returning state's obligations listed in paragraphs 187 to 189 of the Poppish-Billy judgment apply, and those are the provision of evidence.
Yes.
So what does that mean? If it doesn't mean that the person who's saying, I've got such a serious illness that if you send me to country X, that deportation will of itself mean that I suffer a violation of my Article 8 rights on account of the lack of appropriate treatment and so forth there.
My lord, if one focuses on 134, one could read that in two ways. The first way to read it is to say that the appellant must show not only that there would be consequences if treatment is withdrawn, but that that treatment will not be available or accessible in the returning state. That's one way of reading it.
Right.
The other way of reading it is to say that once it is shown that lack of access will result in this, it is for the SSHD to show that that access would be available. I accept that you could read that in two ways, but I don't accept that there is only one way to read it, which is that the burden is on the appellant. Once we accept that there are two ways of reading it, we go on to, in Savran itself, paragraph 140, which puts the flesh on the bones of that test in the way it's applied. And it says that the threshold test must be met, and it is only after that test is met that any other questions, such as the availability and accessibility of appropriate treatment, become relevant. And therefore, at the threshold, those questions are simply not relevant. And again, that is consistent with paragraph 33 of AM Zimbabwe. There's good reason for it, and that is that the state is better placed to get that evidence. It's consistent with what the Supreme Court said and what Papashvili said about the usual burden being adjusted in Article 3 medical cases, and it also gives us a solution that has the benefit of clarity and certainty. This is what the appellant must do, this is what the SSHD must do, and there is no great burden on the SSHD because in the majority of cases, the evidence that she needs to rely upon is already there. It's in a CPIN, or it's available from publications that are available on the internet. She can access, she simply has to address her mind to it, rely on it, and say, this is my case. And that's it. There is no undue burden on the Secretary of State either. It's a solution that has all those attractions to it. If we go with the solution that's offered by the Secretary of State, in my submission, one is not adjusting the test at all. That falls foul of what is said in Papashvili and AM Zimbabwe, that the burden has been adjusted. It falls foul of the reasoning at 33 as to why the burden works in this way. It falls foul of paragraph 140 of Savran, and it also results in confusion. Where is a judge to draw the line as between the initial burden and the consequential burden on the Secretary of State? And one will have a proliferation of litigation because appellants or respondents will say, well, the judge got it wrong on where he was drawing the line. If it's very simple, medical evidence is for the appellant to advance, country evidence is for the Secretary of State to advance. It's clear, it's easily applicable, it's not going to cause much difficulty. The evidence is usually there in a CPIN. It just so happens that in this case, there is no CPIN for Vietnam, but as one can see, the appellant has managed to get expert evidence. The respondent, had she applied her mind to this and discharged her responsibilities properly, would have had evidence, and the judge would have been able to weigh it up. The difficulty in this case, of course, is that the judge got it wrong with respect to the burden. He accepted the threshold test had been met, but then expected that it was for the appellant to then discharge the availability and accessibility burden as well. That's a clear error. But in terms of the issue of principle, we say very clearly that the initial burden is simply in respect of the medical condition and the consequences of taking away treatment and care. Whether that treatment and care is available is the next stage, and that is where the Secretary of State must discharge her burden of proof. That doesn't mean that the SSHD is going to be in great difficulties. I repeat, that evidence is usually very readily available.
How did it work in practice? Let's suppose you were somebody who was very ill and was going to be possibly deported to somewhere where there was obvious doubt about the availability of treatments. But you unwisely chose to simply file evidence of your illness and sat on your hands. Not this case.
Yes.
And the Secretary of State then, for example, put in a CPIM saying that in country X, actually they have perfectly good treatment for this condition. What then follows? Then the appellant then seeks to chase that evidence down by filing evidence of their own. Is there some system for the filing of evidence which would mean that if an appellant hasn't made their case first up, they're not going to be able to save it by filing late evidence further on in the timetable?
Well, my lord, the way it would usually work is that there would be a refusal and there would be a right of appeal against that refusal, so the appellant would be able to respond to the evidence on appeal. And that is the overall mechanism that ensures that the responsibilities of the state are discharged. So the decision-making process isn't viewed in isolation.
I understand your point about clarity.
Yes.
And not wanting to prompt satellite litigations about things of this sort. But at the same time, there seems to be an air of unreality about a seriously ill person raising a claim of very, very grave human rights violation, but not saying something to get their case about unavailability on its feet. And why should we be encouraging an unreality of that sort? As I imagine it doesn't happen very often in the real world.
Yeah.
I mean, really what you're arguing about on this issue is not whether you succeed on appeal, but how much you succeed by. Because you've referred a number of times to the fact that on any basis, whether it's this test or that test, you say you're entitled to succeed on that ground.
Yes.
But I mean, what do you say about the unreality point? People are going to put forward their claim, if it's to be taken seriously, that this is going to place them in a breach situation.
My lord, in terms of the reality,
Yeah.
my lord is right. It's likely that most applicants will produce evidence of country conditions, but it might be that the evidence they produce is not as comprehensive as it should be or could be. And that is why the burden is important, because the detail of accessibility and availability is something, as the Supreme Court has said, that is far easier for the Secretary of State with her resources to investigate. And of course, in this appeal, this appellant has the benefit of legal aid. Most appellants relying on Article 3 medical grounds cases, I suspect, would not have the benefit of legal aid. So there is a resources issue as well. And so whereas most appellants would provide an expert's report, perhaps just what's available online in support of a claim, the question is, is that what Article 3 requires them to do or not? And it's an important question because that might well determine the outcome of an appeal to the FTT. I don't think I can add any more to that. I appreciate what you say about the lack of reality, but that is the way that the test has been set out. And that, in my submission, is certainly the way, if there is any lack of clarity about the position in AM Zimbabwe, paragraph 140 of Savran in my submission does make the point very, very clear. And it is consistent with the reasoning in AM Zimbabwe at 33.
You express concern about there'll be a lack of clarity. At the very least, the position must be on the authorities, if the Secretary of State's right, that the applicant must set up a prima facie case. mean, that's an understandable concept in all areas of law.
Yes.
In the context of Article 3, evidence capable of showing that there's potential violation for these reasons.
Yes.
Now you're saying you don't have to do that, because all you've got to do is show you're really very, very ill, and that if for whatever reason treatment is interrupted or removed, then you will suffer a violation of Article 3, irrespective of where you happen to be. And as soon as that's the position, then you've, without more, established a violation.
You haven't established a violation. You've raised an Article 3 claim that requires a response. The situation where it's established is where the Secretary of State does nothing. And one would not expect that that would be the way that the Secretary of State usually responds. This is an unusual case because there is absolutely no evidence. Usually one would expect that in a refusal, I don't think I've seen a refusal that doesn't refer to objective evidence in relation to availability and accessibility of medical evidence. So as said earlier and repeatedly, I don't think this formulation of the test would place an undue burden on the Secretary of State. It's not something that is going to be difficult for her to do because of the availability of information. My learned friend said you can make a meds COI request. Those are done routinely. You'll get a response that says this medication is available, this medication is not available. So those resources are available to the Secretary of State, utilised all the time. And of course, we only get to that when that very high initial threshold is met. It's not an easy threshold to met. It's not that a seriously ill person will always meet it. So for example, if this appellant simply suffered from PTSD, that would not be enough. There would need to be evidence that removal of the current treatment is going to have a dire consequence. And if PTSD was simply manifesting itself in a depression, medication taken to control that depression, and it was proposed to remove that person, that doesn't get any off the ground in terms of an Article 3 case. That initial threshold of medical evidence is very high. And that is why it isn't a case that anyone that's seriously ill can just simply put in evidence saying, I'm seriously ill, you take me off this treatment and I'll be in trouble. Every one of those cases won't get to second base, if I can put it that way. It's going to be a serious case that gets to second base. But once you've established that serious case, it is in line with the authorities, and in my submission right, when one looks at the balance of resources, that the Secretary of State should then dispel any doubts. And it's serious doubts. So it's got to be something serious.
Well, it's using the words you used a little time ago. It gets you into the ballpark of Article 3. And at that point, it is for the Secretary of State to step up.
My lady, yes. That's right. And it will, I would expect, be a very rare case where the Secretary of State provides no evidence and therefore the claim succeeds. And even in that case, when one looks at the way that Article 3 works, if an appellant succeeds on appeal because the Secretary of State provided no evidence, once that appeal has been allowed, the Secretary of State will no doubt go and do her homework and make another decision saying, well, I've actually looked at the evidence now, there won't be a breach of Article 3. It's not that she's bound by the decision, because the decision is based on lack of evidence. So when one looks at, if one looks at the head note of AXB again, what it says is that at that stage, the Secretary of State is precluded from removal because she hasn't shown that there wouldn't be a breach of Article 3. But she can always show that down the line. So it's not an absolute bar. It's not that the appellant, by sleight of hand suddenly gets leave.
Right, so that may take us to the submission that you trailed earlier on, which was that if you were to succeed on this limb of your appeal, that you should succeed to the extent of the decision being set aside rather than remit it.
My lord, yes. So the appeal in essence being allowed rather than sent back to the FTT or the upper tribunal. And I say that based on head note 3 of AXB, and the way that the burden works, in this case, there simply was no evidence, so the burden has not been discharged. That, of course, does not preclude the Secretary of State from looking up evidence and saying, actually, there would be treatment available and accessible, and making another decision. That is a matter for the Secretary of State after these appeal proceedings have been disposed of.
So the choice that, hypothesising a successful appeal on this ground, that we would be left with would be remitter or setting aside the decision.
My Lord, yes, setting aside the Secretary of State's decision and just allowing the appeal outright.
That is bound to be a question for us, having regard to all the circumstances of the proceedings.
My Lord, yes. I would say that if you accept that the test works in the way that the appellant says it works, then it does fall to be allowed, regardless of the circumstances, because that burden has not been met in this set of proceedings.
That would call upon us, would it not, to find that although the trigger for intervention was a misdirection, or a misapplication rather of a correct direction,
Yes.
that correctly directed the judge could only have reached one conclusion.
My Lord, no. What it would result in is a finding by the court that the judge accepted that the threshold was met. That at the second
Well, exactly,
stage,
but we're saying the same thing.
Yeah.
That typically in this court, we may reverse a decision
yes,
if it's apparent that properly directed, the court below could only have reached one proper outcome. But where that is not the case, then the typical order is to remit.
my Lord, yes. And I suppose what I would say is that properly directed, the first tier tribunal on the facts of this case could only have reached one outcome because of the lack of any evidence from the Secretary of State. If the Secretary of State bore the burden and there was no evidence at all from her, then the only outcome that the tribunal could have reached was to allow the appeal. And I reiterate that that does not mean that the Secretary of State is precluded from marshalling evidence after the determination and making a fresh decision saying that you can be removed.
Yes.
My Lord, if I can, and I know this might not be necessary, but just for the sake of completeness, I wanted to refer my Lords and my Lady to the expert's report, but rather than taking my Lords and my Lady through it now, I could just provide the paragraph references
Would you
by
like to do
email.
that, please?
I think that would be easy, it would save time, and if I can also...
Dr. Tran.
No, this is the Dr. Bangalkote,
Oh,
the psychiatrist, just so that we have a full picture of the evidence that was before the FTT, and also Dr. Tran, because
Yes. Well, please
a full
do.
picture of that as well, because it wasn't just the registration element that he was
No, it was general.
concerned about.
It was the general healthcare.
and also that even if you're registered, you don't get free treatment, you get a subsidy.
Yes, and it's healthcare, cost of healthcare, social attitudes, all
Yes.
of that.
Yes,
Right.
my Lord, yes.
So, would you like to give us Dr. B, please? Just the paragraph numbers.
I was going to send it by email so
I
that I
see.
don't go through it just now.
Fine.
I thought that might be easier. I'll copy in my learned friend and also send the paragraph numbers for Dr. Tran's reports as well with page references. There's just one other thing on the Article 3 point that I ought to say, which is that, of course, if my Lords and my Lady are with the appellant on the correct approach, that might require the Secretary of State to amend her guidance, because the guidance at the moment, I accept my learned friend's point, that the passages that have been focused on by the appellant in the skeleton argument suggests one thing, but if one reads on to the passages that my learned friend referred the court to, they say something very different.
Right. Well, that's a matter that we'll obviously hold in mind, but it's not a matter for us with what the Secretary of State does with our guidance.
The final thing, my Lord and my Lady, is just to refer you to the case of PS cessation, which is at page 6 to 8 of the authorities bundle. If you'll just give me a moment, I'll just refer you to the paragraph numbers that show the way in which the tribunal dealt with what was a similar Article 3 health claim before the tribunal. The relevant passage begins at paragraph 97. And paragraphs 105 to 111 in particular are important. They bring to life the way in which the tribunal dealt with a similar claim. And again, my lords and my lady will see what is typical in these cases, that when applying the various burdens, the tribunal was faced with a situation where there was extensive evidence from both sides. And by the time one gets to the FTT or the upper tribunal, one would expect that there would in fact be evidence from both sides on this point. That just leaves the cessation. If I could just have a very short reply on the cessation issue.
Yes, certainly.
I think my lords and my lady have my submissions from this morning. I just wanted to respond on the Hagar evidence.
Yes.
If I could take you to paragraph 59 of the FTT determination, which is page 84 of the core bundle. My lords and my lady will see that the judge himself did not consider that Hagar had said that there was no risk of re-trafficking. What Hagar said was that they were not aware of any cases where somebody had been re-trafficked. That is very different to saying that there was simply no risk. And from paragraph 55, we have the context of that experience, of Hagar only being able to accommodate 60 people at a time. They said also to the fact-finding mission that they don't really deal with returnees from the UK, and that they don't simply deal with trafficking victims. They deal with all sorts of people requiring support. And therefore, it isn't right to say that Hagar, the evidence from Hagar was that there was no risk of re-trafficking. The evidence from Hagar was that Hagar was not aware of any cases where re-trafficking had occurred. And of course, as I said this morning and referred extensively, and those passages are in my replacement skeleton, there are extensive passages from the CPIN, and crucially, a lot of those passages are from the policy section. So they're not country information, they're the Secretary of State's own interpretation of the country information, repeatedly saying that the situation is akin to what it was in 2010, and there are still risks, and identifying risk factors. So even if Hagar had said there is no risk, that would have to be considered in the context of the other material in the CPIN, which was saying that there is a risk. And in relation to the cessation issue, it is right that the certification is not on appeal, and therefore, even if the appellant is successful, that is not a bar to removal. But of course, that is not a reason why the status of the appellant ought not to be properly and lawfully determined. And what my lords and my lady will see is this is exactly the situation that was before the tribunal in PS cessation, where the certificate...
We agree with that.
Yes.
I'm sorry, would you mind just expressing that submission in slightly different language so I can pick it up and follow it again?
Yes. the cessation issue is important, notwithstanding that certification is not under challenge. So the Section 72 certificate is that the appellant constitutes a danger to the community. And therefore, even though she is a refugee, she can be removed to Vietnam. We accept that. That is the respondent's position.
Right,
But
so
I think
it
it
doesn't
is-
represent a shield, whether or not the status is restored.
That's right, but with this caveat that the finding by the tribunal was in 2021. We're now in 2023, and by the time this gets back on anyone's desk, it's likely to be 2024. So if there is a finding that cessation is not appropriate, the certificate would have to be reviewed in light of the passage of time. If there was an attempt to remove her because refugee status had not ceased, but the certificate was still alive, the appellant would say you need to reconsider whether the certification is still appropriate because of the passage of time, the fact that there has been no further offending, and what the appellant's circumstances are in terms of her health and any assessment of risk of reoffending. My point is that it's important to establish her status, but also that establishing her status might well result in her being able to resist removal on the grounds that she continues to be a refugee and that the certificate is no longer appropriate in light of the passage of time.
Thank you.
Unless there is anything further, I'm going to just, my lords and my lady, with.
No, thank you very much indeed. Those have been interesting arguments. Thank you both very much indeed for the very efficient way in which they've been put. We didn't need 2 days.
No, my.
Don't worry, that clock doesn't
No.
work. Clearly we'll take time to consider it and let you have our judgments when we can. In the usual way, I know I need hardly remind you that they remain confidential until they're properly handed down. You're aware of the rubric that will appear on those judgments. And let us please have no re-argument, but helpful corrections to the drafts and an agreed draft order when you know what our decision is. Thank you all very much indeed.
Court rise if able.